A couple of weeks ago, the search warrant and property receipt from the search at Mar-A-Lago were unsealed. And if you listen to my August 15th podcast episode, I go into the contents of the search warrant and the property receipt. But this past Thursday, there was actually a hearing on the search affidavit. And the media and news organizations and former President Trump himself have called to unseal this search affidavit so that the public can get a look into the contents of it. The search affidavit is the document used to get the search warrant in the first place. So it's different than the actual search warrant and the property receipt. The search affidavit is where probable cause will be laid out. You know how in order to get a search warrant, you have to show that probable cause exists that a crime was committed. So that affidavit is where you'll find the probable cause, as well as what the DOJ expected to retrieve from the property when the property was searched. But the Department of Justice didn't want the affidavit unsealed for the same reason they actually wanted the search warrant sealed prior to the search. Because according to the DOJ, unsealing any of these documents while the investigation is ongoing could jeopardize the investigation. So that's what Thursday's hearing dealt with, whether that search affidavit could be unsealed for the public. Now, what's interesting is that former President Trump's lawyers didn't argue this matter. So his attorney, Christina Bobb, was present at the hearing, but didn't put forth any arguments. This was solely the news organizations and the media, and I'll get into why they were able to argue this in the first place. So the media outlets, their whole point was that the affidavit should be unsealed, noting the historical significance of the unprecedented law enforcement search of a former president's residence, and the immediate and intense public interest, as well as a vociferous reaction from Mr. Trump and his allies. So essentially what the media is saying is, hey, look, this is a historical moment. This is a monumental moment. You know, the search affidavit should be released to the public. The DOJ, on the other hand, says that this affidavit includes sensitive details that risked jeopardizing the ongoing probe. At the hearing, which only lasted for about an hour, the DOJ was represented by one of the top counterintelligence and national security officials, Jay Bratt. Bratt acknowledged the public interest in the matter. He didn't debate that, but he said that there's another public interest here, and that is the government's position to keep the underlying affidavit sealed, because if it's unsealed, it would suggest next investigative steps that the government would be about to take. And obviously the DOJ doesn't want the public in on what their investigation looks like, what's going to happen next, because their investigation could be interfered with. Bratt further argued that the investigation is in its early stages, and he feared for the safety of witnesses and potential witnesses and the threat of possible obstruction and interference. After hearing both sides, Magistrate Judge Bruce Reinhart, which is the magistrate judge that signed off on the search warrant in the first place, said that he doesn't think the affidavit should be fully sealed. He said he believes that there are portions of the affidavit that could be unsealed. And keep in mind, Judge Reinhart, he's familiar with this affidavit because he's the one who had to review it in order to sign off on the search warrant. So he's fully aware of the contents of it. And he basically says, look, like, this affidavit can be sealed in part, but there's portions of it that can be unsealed for the public. So he gave the DOJ until next Thursday to file its proposed redactions. And redactions are basically just where certain portions of the affidavit will be blacked out or redacted to protect the interests of the investigation as a whole or protect people involved in the investigation. It's essentially a protective measure. It protects confidential information, things like that. Bratt argued that redactions are actually not sufficient because information contained in the affidavit could identify witnesses based on descriptions of events alone that only certain people would have knowledge about. So he's saying even if we redact this affidavit, there's still going to be unsealed portions of it that could give away who our witnesses are based on events that took place, when these events took place, that only certain people would know about. So as of now, what we know is the DOJ has to submit their proposed redactions by Thursday, August 25th. My guess is that they redact a whole lot. I think this document is going to be pretty much black. As the DOJ kind of signaled that too. So they submitted a filing previously that said that the redactions would be so extensive that the remaining unsealed text would be devoid of any meaning. So what they're saying is they're going to redact so much, it's not even going to mean anything. The unsealed version won't have any meaning at all. So my thought is they submit a ton of redactions. Magistrate Judge Reinhart doesn't necessarily approve. He says these are too we gotta unseal a bit more. And then in that case, the DOJ would probably immediately appeal, since it's clear that they don't want any details regarding the investigation to be unsealed. Magistrate Judge Reinhart did say that he did say that he may have additional confidential discussions with the DOJ before making his decision on transparency and what will be unsealed. So I think this will very much be an open dialogue with all of the parties to try to come to some sort of agreement as to what can be unsealed. And I did want to answer a couple of questions that I got about this issue. So one of the questions I got was, didn't former President Trump himself call for the affidavit to be sealed? Why wouldn't his attorneys argue this issue? So he did. He made a post on Truth Social last week saying that the American people should be permitted to see the unredacted version of the affidavit and that there should be no redactions in the interest of transparency. So his whole thing is, let's be transparent about this situation. As far as why his lawyers didn't argue, it's not entirely clear. My thought is that his attorneys just want to sit back and kind of see what happens. For now, they can still file a motion. Their time hasn't expired. They can still eventually have a say in this matter, but apparently his legal team just hasn't made a final decision on it as to whether or not they want to get involved. So like I said, they're probably just wanting to sit back for now and see what happens. The second question I got was, and this is a good question, how can the media outlets call for the unsealing of the affidavit when they're not a party to the litigation? So the Washington Post, CNN, NBC News, and Scripps filed a motion to intervene. And essentially what a motion to intervene says is, hey, look, we have an interest in this controversy, and so we need to intervene in order to have a say in the matter. For those of you that watched the Johnny Depp Amber Heard trial, you saw when the TMZ attorney came in, he argued a motion to intervene in order to block the testimony of one of TMZ's former employees. And what was happening there is a TMZ employee was going to come in and testify to who tipped him off to the fact that Amber was going to be at a certain place at a certain time and she had bruises on her face. Johnny's team was trying to prove that Amber's team... Oh, hold on. That was loud. Johnny's team was trying to prove that Amber herself or her team tipped them off to this fact. So they had a former employee of TMZ come in, but TMZ came in and they were like, no, hold on. We have a vested interest here in protecting our reputation and keeping our tips private and confidential. And because of that, this guy can't testify. Like, if he does testify, our credibility goes out the window, and now our tips and our leads know that they can, these tips and leads can be given up through subpoena. So TMZ said they had an interest in this matter and they came in and filed a motion to intervene. Similarly, in former President Trump's case, the news organizations are arguing that they have a right to petition for access to court proceedings and records. And essentially their argument is they've been covering the execution of the search warrant at Mar-A-Lago, and therefore they have the right to intervene for the purpose of seeking access to the search warrant records. And if you're interested in reading their whole motion, by the way, I have this on my website, jordanismylawyer.com. You can go to the episode description page for the August 22nd episode, and you can read the motion for yourself and see kind of what their basis is for wanting to intervene in this matter and their standing to intervene, which means why they can even intervene here. So that'll maybe help you understand. But as far as answering the question, just put simply, it's a motion to intervene, and if they have an interest in the controversy, they can go ahead and file that. So a couple of questions that are worth thinking about. Putting your own curiosities aside, what do you believe is the fair and just route here? So aside from your own nosiness, wanting to know what's in that search affidavit, is this fair? Is this just? Do you think it serves the public interest to have this information made public? Or would you be more comfortable with this investigation playing out behind closed doors, DOJ doing what they need to do, and the DOJ and former President Trump kind of handling this on their own? Do you think also that the news outlets should even have a right to get involved here? Because, as I was writing this out, I thought to myself, is this a selfish move by the media, by news organizations, or do they really believe that the public deserves to know what's in that affidavit? Because we all know what the media does. They do this, so they have the headlines, so they get the clicks, like that's their business. So I wonder sometimes, is this for that? Or do they really think, as they say, the public has a right to know and they deserve to have that opportunity to tell the public? It can be both. It can certainly be a little bit of both, but it's just something to think about. So that's what's going on with the hearing. And obviously there's a lot more to develop in this case. So I will try to keep you guys updated as much as possible. But go ahead and watch my next video. It's on the judgment against Walmart, Walgreens, and CVS for $650 million for their contribution to the opioid crisis in Ohio. Very interesting video. Go ahead and watch it after this one.